Hello, my name is Harman Shergill and I am teaching law at the University Institute of Legal Studies, Punjab University, Chandigarh. We are going to be discussing the topic of fundamental rights and their enforceability. The main headings that we will be discussing in this particular topic are, first of all, what is the concept of fundamental rights? What is the need behind incorporation of fundamental rights in the Constitution of India, as well as the history behind fundamental rights. In addition to these various preliminary topics, we will be discussing the main topic of the question of enforceability of fundamental rights, and thereafter we will attempt to conclude this topic. First of all, these rights are guaranteed by the Constitution of India. These are the rights which have been basically guaranteed by the Constitution to the citizens of India. Fundamental rights are essential for the moral and material development of the people. It is fundamental rights which help develop the people's best self and personality. The concept of fundamental rights being indispensable for the full and complete development of the human personality has been discussed at length under this module. By way of fundamental rights, what the Constitution has tried to achieve is a balance between individual liberty and state power. By way of this module, the learning outcomes which are intended to help the learner understand the basic concept of fundamental rights and their enforceability are to understand the history behind incorporation of fundamental rights in the Constitution and the need for incorporation of fundamental rights. Secondly, to elaborate the concept of fundamental rights. And thirdly, to analyze the question of enforceability of fundamental rights. The first topic that we are going to be discussing is the origin of the concept of fundamental rights. The Magna Carta, in as early as 1215, is the first written document assuring the then ancient liberties to the English people. In France, the Declaration of the Rights of Man and the Citizen in 1789 declared the natural, inalienable and sacred rights of man. The Constitution of the United States thereafter, drafted in 1787, introduced a comprehensive Bill of Rights. The Government of India Act 1935 embodied several prohibitions against discrimination, but they fell short of a comprehensive Bill of Rights. What was rejected by the United Kingdom Parliament in 1935 has commended itself to the framers of the Indian Constitution. Inspired by the Bill of Rights of the American Constitution, Part 3 was incorporated in the Constitution of India. Now, the Declaration of Fundamental Rights in the Indian Constitution is the most elaborate and comprehensive yet framed by any state. The chapter on fundamental rights incorporated in accordance with the trend of modern democratic thought, the idea being to preserve that which is indispensable condition of a free society. Concept of fundamental rights. In this subtopic, we will try to understand what is the concept of fundamental rights. Fundamental rights are regarded as fundamental because they are the most essential for the attainment of the full intellectual, moral, and spiritual well-being of a person. They are the rights which are the basic, inalienable, and natural rights which have been guaranteed by the Constitution of India to its citizens. Any negation of such rights will result in the underdevelopment of the potentialities of the citizens. Therefore, they are essential for the full and complete enjoyment of human personality. Concept of fundamental rights. Speaking about the importance of fundamental rights in the historic judgment of Maneka Gandhi versus Union of India, Justice Bhagwati observed, and I quote, "These fundamental rights represent the basic values cherished by the people of this country since the Vedic times, and they are calculated to protect the dignity of the individual and create conditions in which every human being can develop his personality to the fullest extent. They weave a pattern of guarantee on the basic structure of human rights and impose negative obligations on the state not to encroach upon individual liberty in its various dimensions. Now we will discuss the object behind incorporation of fundamental rights in the Constitution of India. The Indian society, fragmented into many religious, cultural and linguistic groups, it was necessary to declare fundamental rights to give to the people a sense of security and confidence. This was one of the major reasons behind incorporation of fundamental rights in the Constitution of India. Secondly, prevention against violation of rights and interference therewith by an oppressive government was one of the most important reasons why a chapter on fundamental rights was included in the Constitution of India. It was hoped and wished that through incorporation of this particular chapter in the Constitution, the Constitution makers would ensure and give a guarantee to the citizens regarding their natural, basic and inalienable rights which no oppressive government or any government in power could take away from them or abridge them. Thirdly, the consciousness of the massive character of minority problems in India was another factor that contributed towards ensuring that a chapter on fundamental rights is incorporated in the Constitution. Fourthly, in order to establish the rule of law, it was felt that fundamental rights need to be incorporated in the Constitution in keeping with the requirements of the preamble of the Constitution, which has, through which the people have solemnly affirmed to constitute India into a sovereign, socialist, democratic republic. Therefore, these are the various reasons which have contributed to the incorporation of a chapter on fundamental rights in the Constitution of India. The next topic and the most important one that we are going to be discussing is the question of enforceability of fundamental rights. Article 13 gives teeth to the fundamental rights and makes them justiciable. Article 13(1) declares that all pre-constitutional laws shall be void to the extent of their inconsistency with the fundamental rights. Therefore, by way of incorporating Article 13 Clause 1, what the Constitution makers have intended to do is that any laws which were in existence before the Constitution came into force were declared to be void with effect from 26th of January 1950, the date on which the Constitution came into force. According to Article 13 Clause 2, the state shall not make any law which takes away or abridges the fundamental rights, and a law contravening a fundamental right is to the extent of the contravention void. What Article 13 Clause 2 seeks to provide is that all laws which are passed by the Parliament or the state legislatures have to go through the scrutiny of ensuring that they are in keeping with the provisions of the Constitution. Any law which is in contravention with the provisions of the Constitution shall be declared void by virtue of Article 13 Clause 2. Now, the judiciary has been declared as the guarantor, protector and interpreter of fundamental rights by Article 13. In fact, judicial review has been declared as a fundamental feature of the Constitution in the case of Keshwanand Bharati versus Union of India. In this particular judgment, which is a landmark judgment, the court declared that judicial review is a basic feature of the Constitution and it cannot be taken away by any amendment in the Constitution. Therefore, the power of the courts to declare any law which is in contravention with the provisions of the Constitution has been guaranteed by and secured by the judgment in Keshwanand Bharati's case. Now we come to the remedy for the enforcement of fundamental rights, which has been provided in Article 32 of the Constitution. Article 32 confers one of the highly cherished rights. It says that the right to move the Supreme Court by appropriate proceedings for the enforcement of the fundamental rights is guaranteed. Therefore, Clause 1 guarantees the right to move the Supreme Court for the enforcement of fundamental rights to the citizens. Now, it's important and essential to understand what does the meaning of the word appropriate proceedings indicate. What are appropriate proceedings? Appropriate proceedings refers to the purpose and not the form of proceedings. It is the purpose which is essential to ensure that a person who is knocking the doors of the Supreme Court under Article 32 is given due consideration. Now, what is the purpose? The purpose behind Article 32 is for the enforcement of fundamental rights. Any person who is aggrieved may knock the doors of the Supreme Court. Article 32 Clause 2 provides that the Supreme Court shall have power to issue directions or orders or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, and certiorari, whichever may be appropriate for the enforcement of any of the fundamental rights. The writs which have been provided for under Clause 2 of Article 32 are the 5 main writs which have been specifically and expressly mentioned therein. The first one being habeas corpus. Now, the term habeas corpus itself means you may have the body. Now, this writ may be issued in order to set free a person who is, in the opinion of the court, arbitrarily arrested or detained by the executive authority. Habeas corpus is a writ which is issued to a person who has illegally detained another person in order to release that person from detention. It is a process by which a person who is confined without legal justification may secure a release from his confinement. But one of the main important points that we need to understand here is that a petition for habeas corpus is maintainable even if it is filed not by the person who is illegally detained. It may be filed by any other person, but not by any stranger who is a stranger to the person confined, illegally confined. The second writ which has been mentioned in Clause 2 of Article 32 is mandamus. Mandamus means we order. Mandamus is a direction which is issued by a court to a public authority to do its public duty. It is issued against an authority who is under a legal duty to do or forbear to do something in the performance of which the petitioner has a legal right. It is usually directionary in nature. The next writ that we will discuss is certiorari. Certiorari means to certify. It is a remedial writ and is issued to quash an order or decision which has been made without jurisdiction or in violation of the principles of natural justice. Whenever any order is made against any person which is made without jurisdiction or exceeding the jurisdiction which has been given by law to that authority, then that order is bound to be quashed by the court under the writ of certiorari. The next writ, which is very closely related to certiorari, is prohibition. The writ of prohibition, when an inferior court takes up for hearing a matter over which it has no jurisdiction, the person against whom the proceedings are taken can move the Supreme Court for a writ of prohibition, and on that an order will be issued forbidding the inferior court from continuing the proceedings. Certiorari and prohibition being related writs, however, they differ from each other on one of the most important aspects. That being that certiorari is issued by a court after an order is passed, and prohibition is a prohibitory order which is passed by a court prohibiting an inferior court from passing any order which it would pass without jurisdiction or exceeding its jurisdiction. The next writ that we will discuss is the writ of quo warranto. Quo warranto means by what authority. This writ protects a fundamental right from being violated by a government order based upon favoritism. Quo warranto is a writ which is issued by the court to an authority asking that person that by what authority that person is in office. The object of this writ is to prevent a person who has wrongfully usurped an office from continuing in that office. Next, we will discuss clause 3 of Article 32, which lays down that without prejudice to the powers conferred on the Supreme Court, Parliament may by law empower any other court to exercise within the local limits of its jurisdiction all or any of the powers exercisable by the Supreme Court under clause 2. Therefore, the powers which have been given by the Constitution to the Supreme Court under clause 2, which include the power to issue writs in the nature of habeas, mandamus, certiorari, prohibition or quo warranto, or any directions or orders which may be issued by the Supreme Court under Article 32 clause 2 may also be given, this power may also be given to any court in India by the Parliament by law, by virtue of clause 3 of Article 32. Next clause is clause 4 of Article 32, and very important clause which provides for the right which is guaranteed by Article 32, it shall not be suspended except as otherwise provided for by this Constitution, which means that the right guaranteed by the Constitution under Article 32 clause 1 is actually accepted. There is an exception to this right. The exception is contained in clause 4 of Article 32. The exception incorporates that no person can be denied his right to move the Supreme Court under Article 32 except as provided for by this Constitution. Now we need to look into the Constitution in order to find an answer to the question as to what is actually the provision which prohibits a person from seeking a remedy for enforcement of his rights under Article 32. Article 252 of the Constitution provides for an exception to this right guaranteed by Article 32. The emergency provisions contained therein state that whenever there is a state of emergency in the country, then the fundamental rights of the citizens remain suspended. Therefore, during emergency, no person can seek the redressal of his grievance regarding infringement of his fundamental rights under Article 32. Next topic that we will discuss is alternative remedy. Is there any bar to redressal of the grievance of a person or seeking of a remedy regarding fundamental rights in case there is an alternative remedy available? Article 32 is in itself a fundamental right, and therefore the existence of an alternative remedy is no bar to the Supreme Court entertaining a petition under Article 32 for the enforcement of a fundamental right. where once the court is satisfied that the petitioner's fundamental right has been infringed, it is not only its right but also its duty to afford relief to the petitioner, and he need not establish either that he has no other alternative remedy or that he has exhausted all the remedies provided by law but had not obtained proper redress. Now we need to understand against whom a writ can be issued. A writ can be issued against the state. The expression state has been defined in Article 12 of the Constitution, and it includes, number 1, the government and the Parliament of India, that is the executive and the legislature of the Union, the government and the legislature of each state, that is the executive and the legislatures of the states, all local or other authorities within the territory of India, and finally all local or other authorities within the control of the government of India. Now it is essential to understand the meaning of the term other authorities as given in Article 12 of the Constitution. In R.D. Shetty versus International Airport Authority, the Supreme Court in 1979 developed the concept of instrumentality of the state. It also went on to lay down certain tests for determining as to whether an authority would come within the definition of instrumentality of a state and therefore be included in the definition of state as given in Article 12. Another landmark judgment regarding other authorities is Ajay Hasya versus Khalid Mujib, which was passed in 1981. Now this particular judgment laid down the tests to adjudge whether a body is an instrumentality of the state or not. The next question that we need to ascertain is who can apply for a writ under Article 32. First of all, a person whose fundamental right has been infringed has the locus standi to file a writ petition before the Supreme Court for the redressal of his grievance. The legal right to be enforced under Article 32 must ordinarily be the right of the person whose right has been infringed. As rights are different and exist in different persons, therefore it is not competent to a person to seek to enforce the rights of another except when the law permits him to do so. Now this principle emanates from the theory that remedies and rights are correlative. There can be no right without a remedy. In case of a corporation, however, since a corporation has a separate legal entity from its shareholders, a shareholder cannot therefore file a writ petition for the enforcement of a fundamental right belonging to the corporation because corporation is a separate person. Now, over the years, Supreme Court has developed the concept of public interest litigation, which is an exception to the general rule that a person whose fundamental right has been infringed has a right to seek the redressal before the Supreme Court under Article 32. For the enforcement of constitutional and other legal rights. In ABSK Sangh versus Union of India 1981, ABSK Sangh, though an unregistered association, could maintain a writ petition under Article 32 for the redressal of a common grievance. Therefore, the Supreme Court in this case allowed class action or representative proceedings or public interest litigation. In the Judges Transfer case, 1982, a 7-member bench of the Supreme Court has firmly established the rule regarding public interest litigation. The court held that any person of the public having sufficient interest can approach the court for enforcing constitutional or legal rights of the persons and redressal of a common grievance. Therefore, the Supreme Court has allowed public interest litigations or social interest litigations to be filed by public spirited persons in order to seek a redressal of the constitutional or other legal rights of the persons who, by reason of their poverty or economic condition, are unable to reach the courts. Now we will discuss the distinction between Article 32 and 226 of the Constitution of India. Under Article 226, the High Courts have also been given the power of issuing writs in the nature of Habeas Corpus, Mandamus, Certiorari, Quo Warranto and Prohibition. But it is not only for the enforcement of fundamental rights can Article 226 be invoked, but also for the redressal of grievance regarding other rights. Now, in the matter of enforcement of fundamental rights, the High Courts under Article 226 and the Supreme Court under Article 32 enjoy concurrent jurisdiction. Now, the difference in the phraseology of the Article 32 and 226 brings out the marked difference in the nature and purpose of the right conferred by these articles. Whereas the right guaranteed by Article 32 can be exercised for the enforcement of fundamental rights only, as already discussed, the right conferred by Article 226 can be exercised not only for the enforcement of fundamental rights, but for any other purpose. Thus, the power of the High Court is wider than the power to issue writs not only for the enforcement of fundamental rights, but for the enforcement of rights other than fundamental rights, and Article 32 can be invoked only for the enforcement of fundamental rights and for no other purpose. Now, a question has been raised whether a petitioner seeking to enforce his fundamental rights can go straight to the Supreme Court under Article 32, or should he first go to a High Court under Article 226. In as early as 1950 in Ramesh Thapar versus State of Madras, the Supreme Court has clarified that such a petitioner can come straight to the Supreme Court without going to the High Court. Therefore, the Supreme Court has observed that any person seeking to redress a grievance regarding the enforcement of or infringement of his fundamental right can go straight to the Supreme Court without knocking the doors of the High Court. Article 32 provides a guaranteed remedy for the enforcement of the fundamental rights and constitutes the Supreme Court as the guarantor and protector of fundamental rights. Now, this position has been reiterated by the Supreme Court in a number of cases. However, in 1987, a two-judge bench of the Supreme Court in Kanubhai Brahmbhatt versus State of Gujarat has ruled that a petitioner complaining of infraction of his fundamental right should approach the High Court first rather than the Supreme Court in the first instance. The ruling in Kanubhai seeks to negate what the Supreme Court has itself said in a number of cases during the last 4 decades, emphasizing upon the significance of Article 32 and the role assigned to it thereunder. In practice, it seems that the Kanubhai announcement has had no effect on the existing practice, and the writ petitions continue to be filed in the Supreme Court under Article 32 without going to the High Court under Article 226. The next question that needs to be analyzed is as to whether res judicata applies to writs also. When a writ petition under Article 226 has been dismissed by the High Court, another writ petition under Article 32 cannot be moved to the Supreme Court to seek redressal in the same matter. The principle of res judicata envisages that if a judgment has been pronounced by a court of competent jurisdiction, it is binding between the parties unless it is reversed or modified in appeal, revision or other procedure prescribed by law. According to the Supreme Court in Daryao versus State of UP, 1961, the jurisdiction of a High Court in dealing with a writ petition under Article 226 is substantially the same as that of the Supreme Court under Article 32. The scope of the writs under both the articles being concurrent, res judicata applies. The High Court's decision can be attacked in an appeal to the Supreme Court, but not through a writ petition. The last question that needs to be analyzed is whether fundamental rights are available to all persons or all citizens of India, or is there any exception? Article 33 of the Constitution constitutes an exception to the fundamental rights. Under Article 33, a government servant, although is entitled to enjoy fundamental rights, but the Parliament under Article 33 is endowed with power to restrict or abrogate the fundamental rights of a few categories of government servants. A person does not lose his fundamental rights ipso facto by joining government service. However, Article 33 provides an exception to this general rule. Now, Article 33 empowers Parliament to determine by law to what extent any of the fundamental rights shall, in its application to the members of the armed forces or the members of the forces charged with the maintenance of public order, or persons employed in any bureau or other organization established by the state for purpose of intelligence or counter-intelligence, or fourthly, persons employed in or in connection with the telecommunication systems set up for the purpose of any force, bureau or organization referred to in clause A, B and C. Article 33 therefore does not by itself abrogate any rights. Its applicability depends upon parliamentary legislation. Now, this was fundamental rights and their enforceability. Thank you.